All right. Welcome back to the second half of today's doubleheader. So we're going from Nevada, on far south of Nevada to be precise, Las Vegas, all the way up north to the neighboring state of Idaho, which this originates out of northern Idaho, but of course, Idaho Federal Court being in Boise, it is central Idaho. But we're back for more Scofield versus Guillard, the TikTok psychic case. And so, taking a peek at the docket, you'll recall last time we were here was the June 6th motion from Professor Scofield, motion to dismiss for failure to state a claim by Professor Scofield, and a response is due by the 27th. So we've still got almost 2 weeks before we can expect that from Guillard. But you'll recall in that motion to dismiss, basically they said, this is a motion to dismiss only for Professor Scofield because her attorneys are not parties to this case, despite what Guillard claims. And the next day, and then the day after that, we got a status report service of process for Wendy J. Olson, for the attorneys, basically, from Ashley Guillard. And then on the 8th, we got a slew of summonses to the attorneys. But today we got a motion to quash from the attorneys. And so I didn't rush out last week and immediately report on this attempted service, just because I didn't think it was going to go anywhere, and I kind of wanted to do that along with its response all at once, because I figured it would just make more sense that way. So with that, let's jump straight into it. And we have the counterclaimant Ashley Guillard's status report on service of process pursuant to District Local Rule Civil 4.1. And I hate that she puts her address between the caption box and the body of the text, because I don't like putting her address up on screen. If she'd put it in the very top left corner, that would be great. But pursuant to Idaho District Local Rule 4.1, counterclaimant Ashley Guillard submits this status report on the service of process for attorney Wendy J. Olson and Elijah Watkins and Corey Carone. On May 16th, 2023, defendant Ashley Guillard filed a new answer to the complaint, Scofield versus Guillard, and counterclaims. In the counterclaimant Ashley Guillard added the attorneys to her countercomplaint as new party counter-defendants in addition to counter-defendant Rebecca Scofield. The attorneys were served with the answer and counter-complaint on May 16th, 2023, using the CM-ECF system on behalf of plaintiff Rebecca Scofield. Notice was electronically mailed to their email addresses. And on June 7th, 2023, attorney Olson responded with a motion to dismiss on behalf of Rebecca Scofield. On June 2nd, 2023, Ashley Guillard mailed a copy of the complaint, a signed United States District Court, District of Idaho Form 1A, Notice of Lawsuit and Request for Waiver of Service of Summons, and Form 1B, Waiver of Service of Summons, to each new party counter-defendant by United States Postal Service first-class certified mail. To accompany the mailed documents on June 7th, counterclaimant Ashley Guillard emailed each new party a notice of the incoming waiver in the mail, a second copy of the filed complaint, a second copy of Form 1A, notice of lawsuit and request for waiver, a second copy of Form 1B waiver of service and summons, and requested the waiver of service be returned electronically by email. The email was sent to their email addresses. Counterclaimant Ashley Guillard is waiting for a response from the defendants, from the attorney counter defendants. The attorneys have until July 2nd to agree to waive service of the summons and complaint. If Ashley Guillard does not receive a signed waiver from the counter defendants by July 2nd, 2023, she will request a summons and formally serve the counter defendants pursuant to Rule 4 of the Federal Rules of Civil Procedure, dated June 8th. And then we see basically the summons, this one being to Wendy Olson. It says, a lawsuit has been filed against you within 21 days after service of this summons on you, not counting the day you received it, or 60 days if you are the United States agency or an officer or employee of the United States described in Federal Rule of Civil Procedure 12A, 2, or 3, you must serve on the plaintiff an answer to the attached complaint or a motion under Rule 12 of the Federal Rules of Civil Procedure. The answer or motion must be served on the plaintiff or plaintiff's attorney whose name and address are, If you fail to respond, judgment by default will be entered against you for the relief demanded in the complaint. You also must file your answer or motion with the court. And then the proof of service. Hey, there is no proof of service because they haven't been served. They were given a request for waiver, and I'm not going to get into whether or not they needed to waive service or not. And I mean, they don't need to. There's just situations where the cost of service can be assigned to the defendant if they don't waive service. But either way, they haven't been served. But they are arguing, even if we have been served, it doesn't matter because it wasn't proper. So let's take a peek at their motion to quash the summonses for the attorneys. Introduction. Defendant Ashley Guillard has received a second chance to participate in this litigation after defaulting, and she has abused that opportunity by filing frivolous counterclaims not only against plaintiff Rebecca Scofield, but also against Professor Scofield's attorneys, Wendy Olson, Elijah Watkins, and Corey Carone, for collectively conspiring to deprive Ashley Guillard of her rights by suing her for defamation. The counterclaims, in quotation marks, brought against non-parties Olson, Watkins, and Carone are procedurally deficient and brought for no other purpose than to delay the matter and harass the non-parties. Plaintiff brings this motion to dismiss the counterclaim against these non-parties and quash the summonses issued against them. The background. In November 2022, 4 students at the University of Idaho were murdered at a home near the campus. As she has done since 2021 with other crimes, Guillard devised a scheme to leverage the tragedy in Moscow for her personal gain, using her spiritual acuity to post sensationalist content online to attract clicks and make money. The false story that she has posted repeatedly is that plaintiff Scofield, a professor at the University of Idaho, had a same-sex affair with one of the victims and then ordered the murders to cover up the affair. Guillard herself admits to posting over 100 TikTok videos related to her findings about Professor Scofield. After failed attempts to resolve the conflict outside of court, Professor Scofield sued Guillard for defamation. Instead of timely responding to Professor Scofield's claims, Guillard prolifically posted new videos and blog posts defaming Professor Scofield and accusing law enforcement of corruption for arresting and prosecuting Brian C. Kohberger for the crimes. To end the spectacle and to hold Guillard accountable for disregarding the court's deadlines, Professor Scofield requested a default judgment. The court exercised its discretion to give Guillard, a pro se litigant who promised this court she would be timely and responsive, a second chance. Guillard has used her second chance to file frivolous counterclaims, not only against plaintiff Rebecca Scofield, but also against Professor Scofield's attorneys, Olson, Watkins, and Carone, for collectively conspiring to deprive Ashley Guillard of her rights by suing her for defamation. On June 8, 2023, the clerk of court issued summons for Olson, Watkins, and Carone, but they have not yet been served. Guillard's inappropriate attempt to join Olson, Watkins, and Carone as parties to this action is a violation of the federal rules of civil procedure. Professor Scofield now seeks to quash the summonses issued against these non-parties. So remember this morning's video down in Vegas discussing rules 20, the permissive joinder of parties, and 21, the misjoinder and non-joinder of parties. I wonder if Rule 21 is going to show up here. I haven't read it yet, but I wonder if 21 is going to show up here. Argument. The court should dismiss Guillard's counterclaims and quash the summonses issued against Olson, Watkins, and Carone because they are not proper parties to the action. Guillard's counterclaims against the attorneys are unfounded attempts to harass Professor Scofield and her counsel and to delay the proceedings of this case. These counterclaims were not brought in compliance with federal rules of civil procedure, as Professor Scofield's are not parties. Because the counterclaims against counsel are procedurally deficient, these counterclaims should be dismissed and the summonses issued quashed. Guillard's counterclaims fail because the attorneys are not opposing parties within the meaning of Federal Rule of Civil Procedure 13A or B. Guillard's counterclaims cannot be brought against the attorneys under Federal Rule of Civil Procedure 13A or B because they are not opposing parties. Rule 13A and B outline the general requirements for counterclaims. It is a fundamental requirement under these sections that the counterclaims be brought against an opposing party. Federal Rule of Civil Procedure 13A and B. This action is a defamation suit brought by Scofield against Guillard. Olson, Watkins, and Carone are not parties to the suit, and thus counterclaims brought by Guillard against them are improper under the rules. Guillard's counterclaims fail under Federal Rule of Civil Procedure 14 because Olson, Watkins, and Carone are not liable to Guillard for the claims brought against her. Guillard has not met the requirements of Rule 14 for third-party practice. Rule 14 allows for a defending party to serve a summons on a non-party only when the non-party is or may be liable to it for all or part of the claim against it. Federal Rule of Civil Procedure 14A1. It is not enough that the third-party claim may have arisen from the same transaction or set of facts as the original claim, citing Stewart versus American International Oil and Gas Co. from the Ninth Circuit in 1988. Finally, The deadline for a defending party to add third parties under Rule 14 without court order is 14 days after service of the original answer. The attorneys are not liable for any of the claims against Guillard. The claim against Guillard is that she defamed Professor Scofield by posting false and defamatory videos about Professor Scofield. Guillard alone is responsible for that conduct, and Professor Scofield hired counsel and filed her complaint only after Guillard initially acted and then refused to stop. Remember, there were multiple cease and desist notices sent to Guillard, giving her an opportunity to stop before the litigation was initiated. Guillard's counterclaims do not seek to direct liability for the defamation claim asserted by Scofield against her. Instead, Guillard's counterclaims are entirely separate claims against third parties. In addition, Guillard filed her answer on May 16, 2023. Thus, the deadline for Guillard to add third parties without court order was May 30th, 2023. Therefore, Guillard cannot maintain her counterclaims against the attorneys based on Rule 14. Guillard's frivolous and harassing counterclaims fail because she cannot unilaterally join non-parties to the action. Guillard improperly named the attorneys as counterclaim defendants for multiple reasons. First, as set out in Rule 13H, adding a person to a counterclaim is governed by Rules 19 and 20. Second, the addition of parties upon counterclaim is up to the discretion of the court. It cannot be decided unilaterally by the defending party. Third, Guillard's joining of Professor Scofield's attorney to the counterclaims is harassment and frivolous conduct. Federal Rules of Civil Procedure 19 and 20 contain specific requirements for the joinder of additional parties. And I'm not going to go over them because we went over them in this morning's video, well, at least Rule 20, which is the permissive joinder of parties. Rule 19 is the required joinder of required parties. But we went over Rule 20. Watch this morning's video if you want discussion of that. Although since videos on delete laws get like 5 or 6 times the views that videos on Scofield get, I'm sure you already have watched that. So thanks for watching this one too. Considering these requirements, the Ninth Circuit has adopted a stringent test for district courts to apply in determining whether to allow a third party to be joined by counterclaim. See Desert Empire Bank versus Insurance Company of North America, Ninth Circuit, 1980. As a threshold matter, joinder of new parties requires that 1, a right to relief must be asserted against each new party relating to or arising out of the same transaction or occurrence as the original claim, and 2, a common question of law or fact between all parties must arise. Additionally, the trial court must consider the prejudice that may result to any of the parties, the delay of the moving party in adding the new parties, the moving party's motive, the relationship between the original and new parties, the relationship, such as the attorney-client relationship, maybe, the new party's effect on the court's jurisdiction, so like if it would remove complete diversity, and the fundamental fairness in adding the new parties. Given the strict requirements for joinder of new parties, multiple district courts have held that it is the general practice to obtain leave of court to join an additional party to a counterclaim, citing Mountain States Sports Inc. versus Sharman from the District of Utah in 1972. The District of Utah, of course, being in the 10th Circuit. So this is merely, it's not controlling law in the 9th Circuit. I'm having a brain blank here, but it's not controlling in the 9th Circuit, which Idaho is a part of. And that was affirmed. And then also Eccles v. Sharman, 10th Circuit, 1977, Golden Valley Nutrition, LLC versus Immunonutrient Laboratories, Eastern District of Virginia in 2018, and C. Bunamos Biochem versus Zhang, Western District of Virginia, 2018. The court plays an essential gatekeeping function in determining whether non-parties should be added to a counterclaim, citing Desert Empire Bank and Golden Valley Nutrition. Whether to allow non-parties to be joined to a counterclaim, either with or without leave of the court, is therefore left to the discretion of the court, citing Casados versus Drury from the District of Hawaii in 2014. Hawaii is 9th Circuit. Even where a party does not seek leave of a court to add a party to a counterclaim, the court must still decide whether the party should be added, not the unilateral pleading of the parties. See Ignite Spirits Inc. versus Consulting by AR LLC from the District of Nevada in 2022, which held that the court will still decide the propriety of adding non-parties under Rule 13H, even absent parties' contention. Guillard has provided no basis for this court to exercise its discretion to allow Guillard to add the attorneys as parties to her counterclaim. She has not sought leave of the court, and for the reasons set forth in Professor Scofield's motion to dismiss filed on June 6th, the frivolous assertions in her counterclaim make clear that it is improper, serves only to increase litigation costs, and is filed for purposes of harassment. Guillard says her spiritual research intuitively led her to the University of Idaho History Department. She then spiritually inquired into each person listed on the History Department's web page, and her insight for Rebecca Scofield revealed that she was in a relationship with Kaylee Gonsalves that broke up, and that she initiated the murders, planned the murders, and hired help to carry the plan out. Based on these preposterous allegations and still no actual facts, Guillard seeks to sue Professor Scofield and her attorneys, primarily under civil rights statutes, for conspiring to silence Ashley Guillard, to evade suspicion, obstruct justice, and to avoid criminal investigation. And we've gone over why it's inappropriate to even allege civil rights violations, since Professor Scofield is not a state actor, and her attorneys are certainly not state actors. Rather than allow Guillard to drive up litigation expenses and use this court as a platform to continue her spectacle, the court should dismiss Guillard's counterclaims against non-parties Olson, Watkins, and Carone, and quash the issued summonses. Conclusion. For the foregoing reasons, Professor Scofield respectfully requests that the court dismiss all of Guillard's counterclaims against the attorneys and quash the issued summonses. Dated June 13th, 2023, by Stoll Reeves LLP, signed by Wendy J. Olson, attorneys for plaintiff. And it was served on the same day. So that's where we stand as to the counterclaims against the attorneys. I'm going to go out on a limb here. Guillard's she's going to get a chance to respond to this. Her opposition to the motion to quash, it's going to be garbage. The motion to quash should be granted because it is abusive. It is ridiculous. It is wrong. Frankly, I'm surprised that it's so ridiculous that, well, it might still come, but under Rule 11, there are requirements before you can seek sanctions against the opposing party. But frankly, I wouldn't be surprised, as ridiculous as it is, to see Professor Scofield ask for attorney's fees for having to respond to this nonsense. Will they be granted? Probably not, but I'm at least at this stage. But I'm still surprised we haven't seen it yet. So with that, that's where we stand on this. We should have, I assume, a response within 3 weeks on the motion to quash. But within 2 weeks, we should have an opposition from Guillard to the motion to dismiss. As I mentioned, that's due by June 27th. And so, yeah, that's where we stand. Who knows? We could have more nonsense in the meantime, because I don't know what's going on behind the scenes. So there might be other motions in the works, but that's at least where we stand on that. I'm assuming my next video going forward, as I mentioned in this morning's video, Google's self-imposed deadline to respond with its reply brief is the 15th. That is tomorrow, which means, because I record these at night, expect a video on that probably on the 16th, first thing in the morning. And with that, I'm going to leave you here. Thank you for joining me for this second part of today's doubleheader. At a minimum, I hope to see you on the 16th. Do all the YouTubey things if you didn't do them on your way in. Like, share, subscribe, bribe your friends to do the same. And I will see you very soon. Thanks for joining me. Bye-bye.